Yeah, that goes better. I've already spoken quite a bit, which makes my voice is a bit sore, but that will warm up while I'm speaking. So let me first tell you that it is a very great pleasure for me to be here today and to share with you some insights on our case law in relation to general data protection and the accountability in a digitalized world. The Court of Justice, as you know, is playing an important role in enhancing data protection in the European Union. Yet at the same time, it is of course balancing this off against other important values. 2018 is an absolutely pivotal year for EU data protection, with the entry into force, as we all know, on the 25th of May of this year of the General Data Protection Regulation. And I can retain that date by heart very easily because it's the birthday of one of our numerous daughters. So that's why 25th of May, every year I told her, she's a medical doctor, that from now onwards we would not just celebrate her birthday, but also the GDPR. She was not impressed. She said, that's the thing which makes us all these obstacle things, and you have to agree, and you have absolutely no choice to say yes or no, because if you say no, then of course you don't get access. And needless to say, we have already cases now pending on that issue. But I can't speak about them because a judge can never communicate on that what is sub judice. Now, more seriously, the legal and social importance of data protection can be inferred from EU primary law itself. And that needs to be underscored because it's at the level of the constitutional text itself that we find a reference to data protection. That is, for instance, not the case in the European Convention on Human Rights, which is a 1950 convention, 4th of November 1950. There it's only privacy. And the mention of privacy in that convention is already a whole step forward to the United States Constitution, for instance, which is 2 centuries older, and where in a 1965 case, Griswold versus Connecticut, 1965, the Supreme Court, Justice Goldberg, writing for the majority, said that the right to privacy belonged to the penumbras of the Constitution. That is to say, he said, a right without which all the remainder of the Bill of Rights would hardly make any sense. So we did not have to go through these motions of implied constitutionalism reasoning. We could simply rely on a text. And it's not just in the Charter of Fundamental Rights, the Articles 7 and 8, 7 for the privacy right, 8 for the personal data protection, but also Article 16 of the Treaty on the Functioning of the European Union, which counts among the provisions having general application in the EU, meaning that it is a horizontal type of provision which always has to be taken into account in the exercise of any other competence by the Union. You know, the Union rests on conferred competence, so it has always to be taken into account, a bit like gender equality, the protection of the environment, or consumer protection. Those are the so-called horizontal clauses of the Constitution in a substantive sense of primary law of the Union. At the same time, Article 16 is offering a legal basis for the Union to adopt legislation in that field. Now, I don't think I'm telling you a scoop when I say that the Court of Justice takes the right to data protection very seriously. As an EU institution, the Court applies to itself very high standards in this respect, in compliance with the requirements, horizontal requirements there as well, laid down in Regulation 45/2001. But in this speech, I'm not going to speak about the court as an institution for its sort of internal cuisine, although we can certainly discuss that if there should be questions. But it's rather my purpose to give you a very quick insight in the court's contribution to the development of EU law on data protection. And doing so, I shall distinguish two main groups of cases. On the one hand, the court has clarified the scope of data protection rights in cases where public measures interfered with those rights, and where a balance therefore had to be struck between data protection and the protection of other legitimate public interest, or better said, of public interest to court. So it's the data protection rights of an individual against the public interests, legitimate public interests on the other side. A second group of cases, the court is involved in interpreting mainly EU secondary law in a way that plainly fosters accountability of individuals who process personal data. That latter aspect is particularly relevant for today's discussions, as accountability is a central theme, as you know, in the GDPR. So let me first start with the first part. That is the cases where the court safeguarded data protection threatened by public measures nevertheless taken in the general interest. Public measures of general application also. The fight against terrorism, for instance, has led legislative and executive authorities, both at EU and at member state level, to throw the net of surveillance as widely as possible in order to identify potential terrorists and people supporting terrorists, such as financial sources, and to prevent attacks. Those measures, of course, are absolutely liable to conflict with the right to privacy and to personal data protection. In the well-known Digital Rights Island and Zeitlinger case, Digital Rights Island was a reference for a preliminary ruling from the High Court in Dublin. The Zeitlinger case was a reference from the Verfassungsgerichtshof Wien in Austria. So you see how Europe works. It's an Irish judge and an Austrian judge. Those are what I often called the proximity judges, the judges who are close to the citizens. There the cases pop up, very often cases in judicial review of data protection officers here represented on the panel, or their decisions. Or sometimes the data protection officer, her or himself, taking the initiative to take a case to court against an internet player, for instance. That's the recent reference coming from the data protection officer in Ireland, he represented and Schrems against Facebook. So it's all sorts of constellations which are litigated in national courts, and there the question of EU law is sort of filtered out and comes to us in an already pre-reasoned way by a national court. And imagine, national courts are not just asking questions to the Court of Justice like a student would ask a question after the ex cathedra class of the professor. Some further explanation or some further information. I say that somewhat playfully, but it's a real dialogue. So these national courts, they pre-reason what they think of the case. And for instance, I can tell you, in this Digital Rights Island case and the Zeitlinger case, the companion case, they were joined in our docket. When the Austrian court and the Irish court came to us, they said all the awful things they thought of this directive, the Data Retention Directive of 2006, and how, in their view, manifestly breaching it was of these fundamental privacy and data protection rights. So it is, in other words, a question, yes, but it is put in a very engaged manner by national courts, meaning in turn that when this order for reference comes to our court, it is then translated to all European Union languages, notified to all the member states in their language, and then they take a position vis-à-vis, a standpoint vis-à-vis the order for reference as it was put to us by the national courts. So you see, it's a real pan-European debate which takes place on the basis of a pre-reasoned case, pre-reasoned by national courts. So that's the way in which Digital Rights Ireland and Zeitlinger came to our court, and we decided in May 2014 that the Data Protection Directive was invalid. As you may recall, it required member states to oblige telecom service providers to keep a record for at least 6 months of all data relating to telecommunications traffic and location. On 2 requests for a preliminary ruling by the Verfassungsgerichtshof in Austria and the High Court in Ireland, the Court of Justice, as I said, declared it invalid, holding that the directive imposed a disproportionate limitation on the rights to privacy and to protection of personal data. Why disproportionate? Because the directive failed, in particular, to limit the retention of data to what was strictly necessary to the protection of public interest, and also to set out either substantive or procedural criteria determining the circumstances under which national authorities could have access to the data. The court confirmed that the high standard of data protection in the Tele2 Sverige and Watson and others case. 2 joint cases which concern this time national legislation implementing the invalidated Data Retention Directive and thus setting out large-scale retention requirements for telecom operators. The court made clear first that an indiscriminate requirement to retain traffic data and location data, and now it comes, makes it possible to draw very precise conclusions on private lives. What in the jargon is also called, it makes possible profiling of people. If you can know that, I insist the example is hypothetical, that at 3 in the morning in most nights I'm contacting the suicide line, although you don't know what the content of the communication is, you might make some conclusions in relation to my person. I insist that the example is entirely hypothetical. But no, it shows very physically. Or the location data, if in some European capitals, which I shall not now name, but you can maybe think of some, of unfortunately EU member states, you get on your iPhone a message popping up, an SMS. Know that we know that you were there when you're participating in a manifestation, but you forgot to put off your location data device. Of course, there's nothing about content of communication, but I think we all agree that is a rather frightful thing, mingling with your privacy rights and having a clear chilling effect on freedom of expression, freedom to protest, on the normal democratic, pluralistic democratic game where minorities must be able to contest what majorities do if we want to avoid what's already written in the Federalist Papers more than 200 years ago with a view to ratification of the US Constitution, that is the protection of the minority against the oppression by the numerical majority. So, profiling. The court thus said in Digital Rights and worked it out in Tele2Sverige and Watson that given the seriousness of the interferences with the right of data protection, only the objective of fighting serious crime could justify the restrictions. In these two proceedings, a Swedish case and a British case, the general and indiscriminate retention requirements at issue were disproportionate, as they were unrelated to a specific threat to public security and were not restricted to a particular time period, geographical area, or groups of persons likely to be involved in serious crimes. As regards access to the data, the court held that legal provisions must specify the objectives for which data access may be granted, as well as the substantive and procedural conditions governing access. Moreover, except in cases of urgency, access is subject to prior review by a court or an independent body. Now, some may say, and I pause here a moment, some may say, well, but is the court not very exigent? Does the court not know that there is the risk of serious crime, terrorism, and you can't know in advance who will be the ones that may have to be surveilled? That is all very well known. Unfortunately, the court is not a policy maker. The court is a court. That's quite obvious. Meaning that it has no proactive stance, but a reactive stance. It must comply with the rules as they are on the books. So after the invalidation of the 2006 directive, the only rule on the books left is the 2002 directive. For the specialists, you know that by heart, 2002/58. And in that directive, the legislator of the Union, meaning qualified majority in the Council, parliamentary majority in the European Parliament, all of these on a proposal from the European Commission, has decided that the metadata of all electronic communications be wiped out after the time needed for invoicing, including the time possibly involved in litigation about the invoice. And only very exceptionally, it's Article 15 of that directive, can a retention of data be ordered to the extent strictly needed to pursue public order, public security, public health, and so on. And that, of course, we had to interpret like it would be done in any nation-state legal order. The legislation interpreted in light of the Constitution, in this case, Articles 7 and 8 of the Charter. So that is really the context. Now, as I said, Tele2Sverige and Watson refer to serious crime prevention, so the prevention of serious crime, as a possible justification for the retention and access to data, even including data which might allow profiling, as I said. And it's the profiling which meant that the interference with the personal sphere was so serious. Une ingérence profonde, as they say in French. It was a deep interference, a thorough interference, a serious one. And since the interference was so serious, the justification for it needed to be just as heavy. That's why it said serious crime. So then we got, and you see how the case law proceeds, like they say in the common law, one case at a time. So then we got a further question. What is serious crime? And this question was asked by a Spanish court. The problem was the following. It concerned, I'm referring for the specialists to the Ministerio Fiscal judgment of the 2nd of October of this year. So in that case, the main proceedings, that is the proceedings pending in the Spanish court, concerned a criminal investigation for robbery of a wallet and a mobile phone. So it's of course serious to have your wallet robbed and the phone robbed, but I mean, there was no bodily harm, and so that was the sort of the crime. And here, the question was whether the Spanish police could get access to data identifying the users of the stolen telephone, and in order to find these users, the police wanted to make a rapprochement between the SIM cards and the telephone numbers of the SIM cards and the, don't ask me what it is, the IMEI number of the actual phone. So this thing has apparently such an IMEI number, and you can then have several SIM cards with their phone numbers, and then you have the civil identity, that's how it's called, of the persons behind the SIM cards. So that's what the Spanish police wanted to know. And the court said, the first instance court in Spain said, no way. It's not serious crime. It's only a wallet and a telephone, who cares? Serious crime for an infringement in private life. The Ministère Public, they call that Ministerio Fiscal, that does make me think of taxes, but in Spanish it's simply the prosecuting authority, brought an appeal before the, I have it here, the Audiencia Provincial de Tarragona. Yeah, Audiencia Provincial de Tarragona, which is appeals level to that first instance. And they asked us, within the meaning of your Tele2 Sverige and Watson case, what is exactly serious crime? And very politely and diplomatically, we said, you ask us what is serious crime and what should be the criteria to define it, but frankly speaking, the real answer to the question is, it doesn't matter at all. Because even the lightest crime would suffice to have this type of interference in your data protection and in the privacy rights. Why? And that's important for the purposes of this conference. The interference here was not of a serious and a deep type, because the data to which access is being asked are not allowing for the profiling of people's ways of living, so to speak. It's not location data. It's not who communicated with whom, with all the electronic means of communication. It's a very light interference. So there the court says in the interference is it's an interference, but it's a light interference. Therefore, any, even relatively light, public interest is sufficient to justify that sort of a superficial interference. So you see, the proportionality test works both ways. If the interference is very serious, the countervailing public interest which justifies the seriousness of the interference must be a heavily weighting public interest. If the interference is very light, then even a light public interest, such as petite délinquance, can suffice. All right? So I think that's an important thing, because now we have both the Tele2 Sverige, one example on one extreme, and we have Ministerio Fiscal on the other extreme. And you see the test is the same, but the variables factually are different in each case. And it depends on the kind of data you asked. The police only wanted to know the civil identity behind the SIM card number, used with that IMEI number. That's all. It's not a deep interference. It does not allow profiling. And we explained clearly in that judgment of the 2nd of October that that is the trigger. Does it allow profiling or not? So also policy-wise, in balancing privacy and security, we must, I think, keep that criterion. Another issue which the Court of Justice had to address was the transfer of personal data outside the European Union. Those transfers warrant special attention for at least two reasons. First, personal data often do not enjoy the same level of protection in third countries as in the EU. Second, circulation of data has become virtually unlimited geographically thanks to electronic communications. It is against this background that the Schrems case of 2015, and Mr. Buttarelli referred to it, was decided. Schrems complained before the Irish Data Protection Commissioner, here present, that, I don't know whether it was you already, that the transfer of his data from Facebook Ireland to Facebook Inc., Incorporated, United States, was incompatible with EU law because the US does not offer sufficient protection against surveillance by public authorities. That complaint was rejected at national level based on the Commission decision finding that for the purposes of the Data Protection Directive, the United States ensured, I quote, an adequate level of protection of personal data, so that the data could be transferred to that country. However, the Commission had reached that conclusion without really establishing that the United States actually ensured a level of data protection equivalent to that guaranteed by Article 7 and 8 of the Charter. That led the Court to declare the Commission's decision invalid. And here again I stress the following point. The Commission decision dated back to May 2000. That is long before the Charter of Fundamental Rights of the European Union became binding primary law of the Union, which happened, as you know, with the entry into force of the Lisbon Treaty on the 1st of December 2009. The Charter was not even drafted when the Commission was taking its decision. You may recall it was first coming into being as a non-binding text, but already containing the present Article 7 and 8 in December 2000 in the Nice European Council. So in May 2000 it was not even there, the Charter, even not in text. It was in the process of being negotiated. So primary law had developed deeply between 2000 and when this case played 2015. That's one. And second, in the meantime, a certain Mr. Edward Snowden had done all sorts of declarations which the United States had not really been able to contradict or to rebut in any plausible or credible way. So both on the factual score and on the legal score, the case had thoroughly developed. And here we made as a court, it may seem technique to many of you, but a very, very important pronouncement, the consequence of which is that the Schrems case is not only quoted in audiences like this one, for obvious reasons, because it's a data protection case and the conditions of transferring personal data to a third country, but it's also in terms of procedural law of the European Union, a landmark case, because it has made clear that the preliminary reference for controlling the validity of an act of the Union is not only without limit in time, that flows from the treaty and is vested case law, but also may be reviewed in terms of the legal framework existing at the date of the court's judgment, which is radically different than the legal framework which existed at the time that text was adopted. So it's perfectly possible that in May 2000, what the Commission did was felt to be lawful and would not have been annulled at the time, and maybe not invalidated 2 years later by a reference for a preliminary ruling. But now it was. So this dynamic assessment, when time is progressing, may have as a consequence that anno 2015 is invalid what was perfectly acceptable anno 2000. So, and that's of course a proposition which is, but that's maybe my perspective as a judge, which goes far beyond the data protection here. It's really a matter of the legality of the EU institutions' actions must continue to exist over time. So for that proposition, Schrems is also a crucial case. Equally in the sphere of transferring personal data outside the EU, you have, of course, the case law in relation to passenger name records, PNR. The PNR became an important tool after the terror attacks in the United States in September 2001, where several third states started to require, as you know, air carriers carrying persons to their territories to provide detailed information about passengers to their competent authorities, collected and contained in carriers' automated reservation systems. In the opinion 1 of 2015, in fact decided in 2017, the court decided that a PNR agreement with Canada did not contain sufficient guarantees as regards protection of passenger data transferred to Canadian authorities to conform EU standards. The result was that the agreement in its present shape could not be ratified. For instance, the agreement contained the transfer of sensitive data to Canada. And sensitive data are data through which the third country tries to know things about the religious belongings or the ethnic or political background of candidates like this, and of candidates to enter, of passengers. And if you take the legislation of the Union itself on PNR, these sensitive data are excluded. But, I mean, here this was one of the problems. So now I come to the second part, and that is the group of cases which involve threats which private persons, of course, natural and legal persons, the giants of the internet are in this sense private persons, may cause to the protection of personal data. Here again, the court has clearly stimulated high standards of accountability in a series of preliminary rulings interpreting the Data Protection Directive. And that, of course, will now continue in the GDPR. There are a whole range of pending cases, as you know, which came under the directive and where the parties before us now have also pleaded a case under the equivalent provisions of the GDPR, because as of the 25th of May, it is applicable, and since this is all sort of targeting future behavior of these players, they want to have in our judgment two for the price of one. They want to know, what is the past that may be important for liability issues, but they want especially to know what should be commercial behavior for the future under the GDPR. So that's why we now have a number of very important cases. The first case which really served as an eye-opener in this field about accountability of private persons was, of course, the famous Google Spain case decided in May 2014. As you know, the case concerned Mr. Costeja González, a Spanish national who had been the subject of a procedure for recovery of social security debts back in 1998. And that procedure was reported in 2 articles of a Spanish newspaper. One of these articles was digitalized. A search based on the name of Mr. Costeja González on Google returned those articles. As Costeja González considered that those results were detrimental to his reputation as a businessman and were moreover no longer accurate and relevant since the recovery procedure had been resolved for many years, he asked that the link to the search results be removed. Now, Google refused to withdraw the data from their index and to render access to the data impossible in the future. The data protection officer in Spain this time ordered Google to remove. So Costeja Gonzalez went to the data protection officer, said, I agree with you, and ordered Google to remove the link. Google did so. People do not always realize so. À titre conservatoire, they did so to avoid possible future liability. But they didn't agree. So they said, we protest, but we remove anyway to be sure in this concrete case, but we make this into a pilot case. That's how these cases move before courts, right? And they challenged the decision of the data protection officer before the competent Spanish court, which in this case was the Audiencia Nacional. That court referred several preliminary questions to the Court of Justice. And the court came to its landmark judgment of May 2014, which is important for several reasons. First of all, the court held, which was not clear at the time, that a search engine such as Google collects data within the meaning of the Data Protection Directive. Today, within the meaning of GDPR, it's all constancy in the law. Second, the operator of that search engine not only collects data, but processes personal data as it retrieves, records, and organizes the data in question, which it then stores on its servers and, as the case may be, discloses or makes available. That's even the business model. It's because they do that in a free way. You don't have to pay to sort of get the service, but that is the basis on which they can collect publicity and advertising money, AdWords, etc. So that's really the basis of the model. So the code says Google collects data, Google processes data, and Google is not only processing, but is furthermore the controller of the processing as it determines the purposes and the means of that processing. The court recognized here the importance in contemporary society of search engines to enable internet users to access websites relevant to their needs and interests. The counterpart to that large-scale use of search engines is indeed the risk that the right to data protection would be significantly undermined if operators of search engines did not comply with the directive's requirements. So the big operators like Google and other search engine undertakings are obliged persons under that legislation. So that's an important element. Third, as regards the extent of responsibility, the operator is obliged in certain circumstances to remove links to web pages which contain information about a person whose name is used in a search. That is, however, not automatic. That is why the court, in its jurisprudence, never spoke about the right to be forgotten. Common speech is to say, Google Spain, there's a case about right to be forgotten. Make a search, a full text search, not a search engine search, in the text of the judgment, you won't find the right to be forgotten. It is a balancing operation. That's why I say it is not automatic. When operators of a search engine face a request for removal, the court says they should seek a fair balance between the rights to privacy and to protection of personal data on the one hand, and on the other hand, the legitimate interests of internet users in having access to the information. So the first to make that balance is the operator itself. must say, in this case, I prefer the right to privacy. In another case, I prefer the facilitation of access to information. It's a balance, and the code gives a number of criteria in relatively general terms which might be taken into account. If the data subject, that is the person on whose name the search is taking place, is not agreeing with the balancing as operated by the operator, let's now say by Google in this case, then, like happened here, that person can go to the data protection officer, or privacy commission, that is to the official instance in each member state. And that decision is up to judicial review, both on the side of the data subject and on the side of the operator. And then the case comes to us. Now, this is not theory. We have at this moment pending, I just mentioned it pour mémoire, 2 references for preliminary rulings from the French Conseil d'État. But if you take the 2 cases together, they involve, in fact, 7 fact settings, where the backdrop of the reference for a preliminary ruling is Google Spain. They say, we understood what you said. It's a balancing first by the operator, but the operator and the data subject do not agree. So it came to the CNIL, that's the letter word in France, la CNIL. And la CNIL decided, sometimes for the data subject, sometimes for the operator, but either way, it all landed in the court. Tribunal administratif, Cour administrative d'appel, etc. In the end, pourvoi Conseil d'État. And the Conseil d'État says, that's interesting, almost like a common law judge would do. We are going to bundle all of this so that the Court of Justice has a nice florilège of different cases. And there are very savvy aspects in it. There is, for instance, the case where it is the chef de cabinet of a mayor of a medium-sized city, and this is in the run-up to municipal elections, and they are set in the press, digitalized press, to have an amoureuse liaison, liaison amoureuse. And then that's all widespread in the press, in digitalized articles, etc. So if you plug in the name of the mayor or of the chef de cabinet, then you find, of course, the articles to that affair. But a few years later, the relationship has long broken up. In the meantime, the lady finds that now it's time to enjoy the right to be forgotten. And she asks that all these links be removed. And the operator refuses, saying, no, you were public figures. That's not like Costeja Gonzalez, who was a businessman without any further general societal relevance. But you, in the municipality, you had official functions, both you and the mayor. So we refuse. And then the case goes to the CNIL, and from the CNIL to the judge, and now it's with us. That's one of these cases. But then you have another case in the 7 where it's a mise en examen criminel. So someone is suspected to have been involved in a case, and it's widely spread over because this is a well-known figure in the social jet set of a particular city in France, and very much publicized. And a few years later, the person is totally acquitted on the merits. So he is innocent. But the operator says, no, we keep the link because sure, you are acquitted and you always enjoy the presumption of innocence in criminal proceedings, and it was confirmed in a definitive judgment, autorité de la chose jugée, it's final. But nevertheless, the objective fact remains that you have been suspected, and that remains a relevant fact. That's also such a case. And then there is a pedophilia case, unfortunately, and then a few other things, something about a very famous singer. And you see, it's really to get a more precision of these criteria, how to balance the right to data protection and the right to access of information. And you see here, we are speaking about fundamental rights, but notice for the lawyers among you, in a totally horizontal fashion. It's no longer the traditional thinking since the Magna Carta of fundamental rights against public authorities. It is really the rights of one, the rights of others in private relationships, and the judges have to arbitrate that. So that's a step which we have already made, that in such relationships the balancing of rights among inter se, so to speak, of different private subjects, the data subject and the operator, have to come into play. You see now what I meant saying that the code is reactive, not proactive. We have to react when cases arise and then to make and refine our judgments. And I say this with rather a lot of emphasis, because very often in conferences like this one or vis-à-vis media, etc., people take a judgment and then aggrandize it, so to speak, a little bit like a zoom lens, and they take a paragraph and they say, hey, that's now the law. But no, I mean, a judgment is not a statutory provision. It's not a legislative text. It's not sort of decreeing in general terms the law. It is interpreting the law, that's sure, and it goes from one case to the next. It's forming a precedent. It's giving an indication. Next cases will be decided in the same line for reasons of equal treatment, of legal security, legal certainty, but are further developing. So the best picture is to see it as a mosaic in which many little pieces have to be filled in, and it's only with the benefit of hindsight that you can see how the mosaic is making a beautiful or a very ugly ensemble. So we try to have a beautiful ensemble. So we need to have some gifts of anticipation of what it will all then consistently lead to. And believe me, we do our utmost best to ensure that. But it remains one case at a time, like the common lawyers say. And that's also the perspective of these preliminary references. Now, two judgments pronounced earlier this year fully confirmed the court's attachment to high levels of accountability. You probably know them. As far as private parties are concerned, obliged to the fundamental rights of privacy and data protection. The first is a case called Wirtschaftsakademie Schleswig-Holstein, a case decided on the 5th of June of this year, and which concerned, like in Schrems, but from a different perspective, Facebook. The court decided in essence that the administrator of a fan page on Facebook is jointly responsible with that social network for the processing of data of visitors of the fan page. The court observed that the fan page administrators can obtain from Facebook anonymous statistical data on their fan page visitors, collected by means of cookies. However, neither the Wirtschaftsakademie Schleswig-Holstein, a German company administering the fan page, nor Facebook itself informed the visitors of that fan page that personal data concerning them were collected, let alone that they would have asked their consent. So that eventually led the data protection supervisory body in Germany to order that company and Facebook to deactivate the fan page. So you see, it's always the National Data Protection Officer body, or whatever the name, which differs a bit from one member state to the next, which steps in and says, stop it, or refuse to stop it, and then depending on the sense of that decision, the case comes to court. Of course, that decision to deactivate was attacked in German court, and the German court makes a reference for preliminary ruling to know what the state of play under union law is. The court, first of all, our court confirmed that based on existing case law, Facebook itself must be regarded as a controller responsible for processing personal data of Facebook users. So it's a very heavy pronouncement in terms of legal consequences. So it is Facebook is a controller responsible for the processing of personal data of Facebook users, including those of a fan page. The main novelty of the judgment, however, is that a fan page administrator must be regarded as jointly responsible for such processing. So it's not just Facebook, but it's also the administrator of the fan page on Facebook. The administrator indeed defines the parameters of data collection, which may, for example, concern age, sex, relationships, occupations, lifestyle, purchasing habits. Do you again see? Profiling, huh? That's always the key. Does the data collection allow profiling? Big data. Depending on how it plans to promote its own activities. And it is the administrator of the fan page. And although it is Facebook that formally collects the data, the fan page administrator takes part in the determination of the purposes and the means of processing of the personal data of the visitors of the fan page, including visitors who have not themselves a Facebook account. That was a very important point. I can access a fan page, all my data are being collected through cookies at my ignorance. I don't know anything about it, let alone I've been asked for my consent. And that goes in the Facebook system, and my data are being used as a merchandise in order to give to the fan page administrator, against, of course, payment by the fan page administrator to Facebook, all that he needs to know to conduct his business. That joint responsibility plainly contributes to ensuring more complete protection of the rights of persons visiting a fan page in accordance with the Data Protection Directive, now GDPR. A last case very briefly, because it is not one in the digital field. And it's important to also keep in mind, and I say it almost pro memori, but it's important to keep in mind that personal data protection and right to privacy is not limited in our modern age to digital matters. And this is the case known under the name Jehovan Todistajat, which is the Witnesses of Jehovah, a case decided by the Grand Chamber of our court on the 10th of July of this year. The Finnish data protection supervisor, you see I haven't mentioned any of the cases where the National Data Protection Authority is not involved. Huh? The Finnish data protection supervisor, that's the name there, prohibited the Jehovah's Witnesses from collecting or processing personal data in the course of door-to-door preaching by its members, except where the contacted persons expressly consented to it. Members of the Jehovah's Witnesses take notes when they carry out their door-to-door preaching. They take the notes just in handwriting on a sheet of paper or in a little booklet. Once they have these notes taken at the door or immediately thereafter, they retranscribe the content of their discussions, and in particular the religious views of the contacted persons. So the notes are, in fact, I was received so-and-so, and I think the person is agreeing or not agreeing and is belonging to another religion, and in some which one, or is very much opposed to any religion whatsoever, and it's all neatly noted down. Our court took the view, the question was, is this prohibited or not under the data protection legislation of the EU? The court took the view first that such door-to-door preaching is not covered by any exception in the Data Protection Directive. You know, the exception that for purely personal or household activities you can fall outside. Because, of course, here it is not something which you do in the internal sphere of your personal or household sphere. It's precisely a contact with a person whom you go see in his house à la limite, but you go very far outside your own house as a preacher. That's precisely the whole purpose of the activity. So that was plainly not applicable, this exception. Second, insofar as the data at issue are structured according to specific criteria, which enable them to be easily retrieved for subsequent use, for example by geographic area, they form part of a manual filing system subject to the Data Protection Directive. And that's important because we are now so used to digitalized and formatized systems of ordering data and getting easy access to data under specific search or keywords that we would forget that also a manual filing system, the old-fashioned cards in a box, like the old-style libraries, it's still also a system of a filing system which is covered by the EU legislation. Third, as regards responsibility of private persons again, the Code built further upon its judgments in Wirtschaftsakademie Schleswig-Holstein and held that subject to verification by the referring court, that's always a matter of division of jurisdiction, the facts are for the national court, we say the law, both the members of the Jehovah's Witnesses and that religious community itself jointly determine the purposes and the means of processing and may thus be regarded as a controller under the Data Protection Directive. The Code emphasized in particular that the Jehovah's Witnesses community organizes and coordinates the preaching activities of its members, even if it does not necessarily, as a community, have access to the personal data collected from the contacted persons. So in the end, it was the Jehovah's Witnesses community, which is a legal person under Finnish law, and the individual preachers, which were jointly responsible for the collecting of the data. At present, we have many, many pending cases. We have, of course, already mentioned the Irish Data Protection Officer plus Schrems against Facebook. It's a big case. We have the Privacy International case, which is referred on big data by also French Supreme Court. We have the already mentioned cases on the, I say it now myself for ease of speech, the right to be forgotten, but in these 7 cases with different balancing fact settings. And then we also have a very, very important case which goes under the name Planet 49, which will be argued in open court before the Grand Chamber of the Court in the coming weeks. And this, in November, this Planet 49 is the whole thing about cookies. That is the consent which is asked that cookies be used before you get access to a site, either a site for information or a site on services or whatever, is that a free and informed consent or not? So it's a very basic question on the whole cookie policy of many internet, well, not internet providers, but many providers of services or of information via the internet. So I don't have to explain in an audience like this one why that case went to the Grand Chamber of the Court, which is a decision taken by all the judges and advocates general that we go in the Grand Chamber in order to decide these cases. I cannot, of course, speak about these pending cases. Huge interests are involved, economic interests, but also societal interests. Because, of course, the internet is also a fact of life. We are very much for privacy, we are very much for data protection, but we are also very much for freedom of speech, for freedom of access to information, and for just ease of the social and the mercantile life of providing goods and services also over the internet. So how do you have also the freedom of enterprise, basically, to conduct a trade and a business? So, in fact, the image which I want to carry over is that when we see that in our code, the big challenges for the future are no longer so much the cases in my first half of the speech, that is opposing private parties to public authorities. They're still there, but they're rather well circumscribed now. The big challenge is in the second part, that is the balancing between private persons' rights on either side, the data subject and the operator. And this in the widest variety of case settings, and I'm sure that we will, for many, many years to come, have to balance these rights. In any event, I can tell you that when the court is dealing with such balancing of rights, we are strictly inscribing ourselves in the values on which the European Union is founded, the first one of which is mentioned, it's often forgotten, is freedom. The order is freedom, democracy, rule of law, fundamental rights, and then a few more, just as important, gender equality, solidarity, mutual respect, and so on. But it all starts with freedom. And so that is why the protection of privacy, the protection of personal data being an expression of freedom, the freedom from oppression, whether it be by a political majority or by a giant of the internet as a private operator, must be protected. But there are countervailing values. There are public interests which outweigh or weigh at least up against the protection of privacy, and the same applies to the values which operators of data systems are acting for. It's of course the giants of the internet are acting for their own economic interests, which is quite all right. That is the freedom to engage in a trade and a business. There's nothing wrong with that. And they're also at the same time, by proxy if you like, acting on behalf of all those who over their services get a better access to information, which is part of the freedom of expression. Those are the big challenges. Our court will go on within the framework of its central mission statement, which is Article 19 of the Treaty on the European Union, that is to uphold the law in the interpretation and application of the treaties. It is roughly equivalent to what Chief Justice Marshall of the United States Supreme Court said in 1803, in his Marbury versus Madison judgment. He said, "It is emphatically the province and the duty of this court to say what the law is." And then he goes on explaining that politics is for the politicians, but the law is for the courts. It's of course largely begging the question, which he must certainly have been aware of, and we are in the same position also more than 200 years later, what is the precise line between law and politics? But that I let you to judge. Thank you very much.